Okay, so you're good evening to you all. You're all very welcome to this book launch. It's really lovely to have you all, and thank you very much for joining. It's a great pleasure to have some form of cause for celebration in these times of Zoom in 2020 at all. So thank you very much for being here, and thank you. A huge thanks to Heart Publishing, to all of the contributors, and to Anu Bradford for writing the foreword to this book. It's been a great pleasure to do this project, and it's so lovely to have some kind of celebration event to mark its formal publication. And the book is a very long time in the making, in the sense it's the culmination of many different projects, perhaps 2 workshops, one in 2017 November, another in 2018 in November, and it contains a very broad span of people, of subjects, and of issues. Unashamedly, it's a project which is quite interdisciplinary and looks at very much the how question. So how does the EU engage with the global legal order? And it's been such a lovely group of people to get to work with for some time. And I think the project's timeliness has increased substantially since the project was perhaps conceived. And that's not something always academics have to deal with, certainly not people nowadays, for example, who are dealing with Brexit. So it's really wonderful to see the book being received very well already. So thank you very much to all those who are engaging with it. A special thanks also to the EU TIP project, which is a Horizon 2020 funded Marie Curie ITN. There's several people from the project, including early stage researchers and supervisors involved in this project. So it's wonderful to have them. The project also benefited from a huge amount of reviewers, external individuals who gave lots of their time to read chapters and give lots of comments. So I hope that you agree that the project is, in the end, is a very nice production overall. So that being said, I thought we were delighted to be able to invite Advocate General Gerard Hogan to give a few welcoming words on the launch of the publication of the book. And Advocate General Hogan has joined the Court of Justice in 2018, and prior to that, it was a very distinguished jurist and member of the judiciary in Ireland, and indeed it's seminal scholar in the area of constitutional law. But his involvement in EU international relations law, I think, has been of some note, and particularly before coming to the court, as to the EU-US Privacy Shield and transnational data standards, and also since coming to the court on the constitutionalization of the common foreign and security policy in cases such as Bank Rafeh Karagan, but also in Zugut and the Israeli settlements and the interplay of EU consumer law, food law, and international law. And I think he embodies well a lot of the ambitions of the project, that the EU increasingly has so many more subjects and objects and engages as a global actor in so many ways in the global legal order. And it's just a fact of life that there are more cases coming to the court and coming to the attention of scholars, who as a result with projects such as this that emerge. And so we thought that we would invite Advocate General Hogan to say a few words at the launch, to mark the formal launch of the publication, followed by all of the contributors to give a very short outline of their publication. So without further ado, thank you very much, Advocate General, for joining us today in these times. Gerard.
Thank you so much, Elaine. It's a great pleasure to be invited, and it's really humbling to see true scholarship with a book of this kind. And I can only unfeignedly marvel at the quality of the writing and the research and the specialist nature of the work. And when I read something like that about EU law, I really wonder, am I in the right place? But however, rightly or wrongly, I've been put in that place, and the task falls to me. But it is really a great pleasure to be here and to say something about the book. Now, I think Elaine has strictly and very wisely confined me in terms of time. So I've only got about 5 or 6, 7 minutes to say, just to speak to a few themes that relate, I think, to perhaps the overall objective of the book and some of the individual essays, if I can. And I suppose the thing that occurs to me, one could say many, many things in response to this book, but one thing that I think it brings home, and indeed if I've learned anything in 2 years in the Court of Justice, it is how much international law and externality is a feature of the Court of Justice. And in some ways, given really how few cases in practice go to the International Court of Justice. And features of the court, especially perhaps in the last decade, and maybe even especially again in the last 5 years, is the extent to which the Court of Justice has become an international law making court, if I can say that. And I don't do that in any sort of way of self-aggrandizement or seeking to elevate the status of the court beyond that which it deserves. But in practice, faute de mieux, as it were, the court is finding itself having to resolve a range of international issues, which in turn, I suppose, contribute not only to international law and international practice, but also have de facto consequences outside of the European Union. Now, many of these themes are brought up in the various essays in this book. And I hope nobody will mind if I just focus on 2 or 3, because I could speak about so many themes, but if I can just focus on this international law, either for the court, one can broadly separate them into a number of different areas. So, for example, as Professors Cardwell and Vessel point out in their essay, the Court of Justice has been obliged through a series of cases in a range of different areas to pronounce on territorial questions. So we've had that in the Front Polisario and the Western Sahara cases. You had it at an earlier stage in some of the Cypriot cases. You had it, I was the Advocate General in the Organisation Juive Européenne case concerning the wine production from the Israeli settlements in the West Bank. One can see that inevitably the court has been forced to confront these sort of issues from time to time. The second type of case is, I suppose, technical aspects of international law. So, for example, in the Whiteman case, there was the issue about the circumstances in which the withdrawal of a treaty from an international treaty could itself be revoked. Now, that's a very interesting and important technical question of international law on which there wasn't, I think, a great deal of authority before this, but Whiteman is now, perhaps in its own way, as definitive on this technical topic as any decision of the International Court of Justice. I just mentioned in passing another case that's on my desk, in which due to give an opinion, I think in January, concerning the question of whether a state, a third country state, can actually sue before the Court of Justice. In this case, it's proceedings brought by Venezuela challenging effectively the imposition of sanctions on that regime in the wake of the 2018 election. Now, one of the questions the court will squarely have to consider is whether a third country state, such as Venezuela, is a legal person for the purpose of Article 263 TFEU. Now, and obviously I'm not going to say anything more about that question, but simply to say the fact that it is before the court is itself, I think, of some importance in terms of, again, international law practice, because apart from the Banco Nacional de Cuba case in Sabatino in before the House of Lords in the 1970s, there's not a lot of, really, a lot of international authority on that particular question. And then, as I think Professor Gatti points out, you've had the ACMEA litigation concerning, if you like, intra-EU investment tribunals. That has one consequence, if you like, for states within the EU, but it also has perhaps implications externally as well. And then there is the question of so we had the recent judgment in the Bank Rafa Carrigan case, which Elaine has mentioned, which I happen to be the Advocate General, and the court gave a judgment on the question as to the extent to which damages could be awarded in certain circumstances for a breach by the Union of fundamental rules relating to the common foreign and security policy. So, and then touching on Professor Nicola's essay on the issues of global convergence and the resistance to global convergence, again, that was sort of theme close to my own heart, because as luck would have it, and it was just sheer serendipity and luck that I happened to be assigned the rather unprepossessing case of Schrems and the Irish Data Protection Commissioner when I was a judge of the High Court in April 2014, and that led to a reference by me under Article 267 to the Court of Justice. And then I suppose, having no more than, as it were, thrown the ball in or kicked off, or whatever a sporting term you want to use. Maybe I was the equivalent of the honorary starter at the US Masters, whereby I just hit a weak shot into the rough and then the game started. But in any event, I mean, the court has taken that issue with Schrems, and now we have Schrems 2, Teletuosferia, and a whole range of other important cases, which not only deal with the question of the GDPR and the way it operates in data protection within the European Union, but as we've seen from Schrems 1 and Schrems 2, it's had very important consequences in its own way, perhaps has had certain ripple effects, even within the United States. I'm sure that many US lawyers would deny such a thing, or that even the FISA court, the intelligence security court, was even aware of the decisions in Schrems, but I'd like to think that perhaps it had some knock-on consequences. So what I get from this essay, from these series of essays, is not only in terms of, is true, not only in terms of court decisions, but also in terms of both soft law and legislation, the way in which EU standards, again, faute de mieux, are sort of exported around the world and have knock-on ripple consequences in unexpected places and in unexpected events. And I suppose in some ways, if you are a proponent of the chaos theory of evolution, or the chaos theory of how the world works, sometimes, so that a butterfly in Ecuador can have consequences in Europe. Well, sometimes perhaps unexpected things happen externally by reason of not only decisions of the Court of Justice, but also the actions of the EU generally in both its executive and legislative arms, so that without seeking to be, I think, a major player in sort of superpower geopolitics terms, that it's had nonetheless important consequences. And many of these consequences are the subject of highly accomplished specialist essays in this book. And can I just finish on this theme? One of the, this is obviously very specialist work by a variety of highly accomplished academics and professionals. But one of the things that I really liked about it, and one can't always say that with monographs of this kind, is how easy on the eye it all is. It's a beautifully produced production as befits Hart Publishing, but also the essays are I can't always say that about monographs, but it's true here. And I think for all of those reasons, all of you deserve the highest praise. It's a pleasure and an honor to be asked in some way, I suppose, to I can and I. Elaine, thank you so much for doing me the great honor of being in such exalted company, and it's kind of humbling to be able to do this, and thank you very much.
Thank you very much, Jared, for your very kind words and for very interesting comments indeed. Thank you so much for that. And without further ado, I'm going to move on to ask Anu Bradford. I think you, very nicely the foreword I think that you have written, and also your work fits very nicely with the manner in which Jared, the Advocate General, has finished off his comments as to how the EU acts in the world. Anu, can I go to you very briefly, please?
Yeah, thank you so much, Elaine. And let me just indeed be very brief. There are so many rich substantive chapters, and I think I really want to give the floor to everybody who contributed. But I want to really offer my sincere admiration and congratulations for this terrific work. And let me maybe just highlight how I find that the timeliness and the importance of this book is just really something that I think we all acknowledge, and that is truly remarkable. That if you think about the foundations of the global order, they are really questioned today in a way that has not been the case for the decades prior. And I think it places an even stronger responsibility for all of us, many of whom I would say count ourselves as some of the strongest supporters of the global order and the European Union. But we are the ones who should be asking the hardest questions in order to reshore the foundations of that order and really contribute to that debate so that that order would be capable of challenging, responding to some of the deepest challenges that it is facing. So in many ways, I consider this contribution as an invitation to have that debate in a way that is deeply informed, that is creative, that is committed to scholarship at the highest level, and that really understands the context within which all these individual debates proceed. So in many ways, I think the challenges today are a call for the academics, for the policymakers, for the companies that are participating in the global order, to really have that debate with an increased intensity and commitment. And in many ways, I view this book as the one that is charting our way for that conversation. So I really just admire and offer my congratulations for this terrific work. So thank you, Elaine. Congratulations, and congratulations to everybody contributing to this volume.
Thank you so much, Anu, for that. That was fantastic. Can I move through then to the contributors to ask them all to just introduce themselves very briefly in their chapter. Frank Hofmeister, could I turn to you next? Frank, thank you very much, Anu. Hello, Frank. Yes. I think you're on mute, Frank.
Yes, hello, Elaine, can you hear me?
Yes, I can. Hi, Frank. Good evening.
Yes, sorry for the technical hiccup. Yeah, I'm Frank Hofmeister from the European Commission and University of Brussels, and I addressed the question of how the EU's free trade agreements relate to the WTO legal order. And my findings are briefly the following. It's, on the one hand, the EU tries to reaffirm the WTO rules. For example, only substantially all trade is regulated by an FTA. At the same time, we go beyond the WTO standards, so building on, especially on tackling technical barriers to trade, and also on procurement. The EU goes much beyond what is agreeable in the WTO under the GPA. The third issue is also reform. The EU is in for some reforms, and the best example is international investment law, where now there is this huge initiative at the UNCITRAL to even found a multilateral investment court. Of course, there are some issues which third states also see critical. So the EU's restrictive practice on liberalization on certain services, let's think about audiovisuals, and also the EU's approach on SPS measures is sometimes seen critical by third parties as going a little bit below the WTO objectives. And finally, the EU in its practice seems to be progressive, and when we look at sustainable development, a chapter there has really brought the issue to the forefront, and it is not excluded that this will go on. So in short, the thing is not so easy to coin in one sentence, but I would say the EU is not setting the standards, but shaping the standards on global trade law. Thank you so much for this wonderful book, Elaine. That was my short summary of my chapter, please.
Thank you very much, Frank, for such a precise and concise summary. It's been a pleasure to have you part of this project. Could I hand over next to my colleague, Jed Odermatt. Hi, Jed, are you there?
Yes, I'm here. Hi, Elaine. Thanks for inviting me to be part of the book as well. My chapter, Convergence through EU Unilateralism, it uses those concepts you've used in the book of convergence and divergence to address this issue of EU unilateralism, which, when I say that word, some people may have a negative connotations with it. It's often used to describe what's done by the US as a superpower when it acts in international law as a unilateral actor. And so it's sometimes seen as a negative term used when applied to the European Union. But I wanted to address this idea of unilateralism seriously. And it's not a chapter where I either support or tear down EU unilateralism, but to kind of address the benefits and drawbacks of it and assess it in light of the EU's professed obligations and commitment to multilateralism, and see whether or not there are negative effects associated with unilateralism in the case studies or examples that I talk about. Individual sanctions, data protection, and activities to address climate change. And I also address this idea that's sometimes used of contingent unilateralism, the idea that if multilateralism no longer works for the European Union in these areas and other areas, it can kind of go it alone. But again, addressing some of the drawbacks and negative consequences that can happen for the EU and its other partners when it decides to pursue that unilateral approach. And I say in the conclusion that contingent unilateralism is still a form of unilateralism. So that's my brief overview of the chapter.
Super. Thank you so much, Jed, for a great chapter and for a very nice summary. That's fantastic. And can I hand over to you, Machiko Kanetake. Machiko. Hi, Machiko.
Hi, everyone. Can you hear me? So I'm from Utrecht University in the Netherlands, and it has been such a pleasure to work with Elaine and other authors in the context of this volume. So my third chapter is about EU's export control policies, more precisely on dual-use export control. And I'm not sure if you have heard of it, but after the Arab Spring, there have been a lot of political controversies regarding the role of EU companies that have sold surveillance technologies to those governments which have experienced popular uprising and tightened the surveillance of dissidents and wider citizens. So in response, European Commission has proposed to strengthen the regulation technological trade based on human rights implications in destination countries. But this idea to strengthen the human rights approach got resistance and rejection from many EU member states and industry associations. So on the basis that this export control is about controlling the military risks instead of human rights risks. So my chapter highlighted different viewpoints on how the EU should integrate human rights in its external action, focusing on dual-use export control. And this topic is also quite timely because a few weeks ago, Council and Parliament agreed upon a new form of dual-use aggression, focusing, integrating also human rights approach. So I hope this will also contribute to the public debate as well.
That's fantastic. Thank you very much, Machiko. That's fantastic. Really, really nice to hear from you. And can I move on to Mauro? Mauro Gatti? Mauro, are you there?
Hi. Yeah, I am. My chapter focuses on international investment agreements and makes 2 points. In the first place, I claim that international investment agreements promote convergence at a global level in the sense that they incentivize states not to enact or not to implement legislation in the public interest, to the extent that they discourage states from adopting environmental legislation or healthcare legislation, insofar as states might be sued in case they adopt such legislation, and they have been sued in the past. I argue that well, some member states of the European Union have created this system, and this system is profitable for the companies of these member states. However, the European Union and the member states have recently decided to adopt a more critical approach towards international investment agreements for 2 main reasons. First, some middle-income countries, which are countries of destination of investment, became members of the European Union some 15 years ago. And secondly, some member states that are traditionally origins of investment became also defendants in some occasions before investment tribunals. Therefore, the public opinion in those countries, notably Germany and the Netherlands, became quite critical of investment agreements as such. Therefore, firstly, the European Commission and then the Court of Justice have found in different ways that investment agreements should better protect the right to regulate of countries. And in this way, the European Union is slowly diverging from the convergence that used to be promoted by investment agreements. Investment agreements promoted convergence towards deregulation. Now the European Union is diverging from this paradigm. It is converging towards the position of those developing countries, such as Brazil, that have always found that promoting the protection of investors is not necessarily the first priority, but other priorities are relevant as well, such as the protection of the environment or indeed human rights.
That's great. Thank you very much, Mauro, for that summary. So we move on to the part 2 of the book, which is about the global legal order against convergence. And can I move on to you, Fernanda, for your chapter, Fernanda Nicola, on resistances to global convergence?
Sure. Thank you, Elaine, and congratulations again. It was terrific to hear all the speakers and the Advocate General, Olgan. Here, let me say 2 things that my chapter does. On the one hand, I take a bit the Polanyi's framework of counter movements and thinking about convergence, that there's always counter movements to that convergence, whether that comes in the more ideological or in more descriptive ways. You're going to have forms of resistances to whatever is the main convergence force. So I basically sketched 4 types of convergences that can be seen, especially my examples are more regulatory in terms of, for instance, the privacy example. Schrems 2 is a great example, even Privacy International today, where if we think about a Western legal convergence over privacy law, we see in the Schrems 2 decision that the effects of the Court of Justice decisions are very much creating somehow chaos, but mostly more than chaos, there are ways to rethink what does it mean, for instance, bulk access in data privacy, right? And so the idea is, will the intelligence community, not only in European Union, but also in the US, readdress how do we allow our citizens to have access to data when this is under the coverage of national security. But let me tell you, these 4 types of resistances that I saw are called what I call local resistances, institutional change, decolonization, and democratic resistance. So what I say is that once we frame these resistances to global convergence, we have to take our research more seriously and do some empirics to figure out what are the distributive consequences of those resistances. Are they effective? Is this global convergence really create some resistances? And what does that mean in terms of the cost and benefits that they create in terms of international agreements not going through, transatlantic cooperation failing or achieving something, and which groups benefits or do not benefit from this? And so the chapter ends saying that these forms of resistances might ally, cooperate, or work against each other in making some types of regulatory cooperations, for instance, happen or not happen. And I also wanted to bring another force, which was the Belt and Road initiatives, into all this, because I think we need to move away from only the transatlantic perspective and really think about what's the role of China investment, China financing, and Chinese somehow also regulatory models that are going to become, especially in environmental, for instance, protections, they are becoming a real player. So that was the idea behind my chapters. Again, thank you, Elaine, for this great collection.
Thank you so much, Fernanda, for that. That was brilliant and for a great chapter. Can I move on to David Hainig? I'm taking him away from the Brexit negotiations. I know he's been very busy. David, are you there? Hi, David.
Yep, I'm here. So yes, this is a previous trade negotiation I was writing about, the US and EU negotiation for TTIP, Transatlantic Trade and Investment Partnership, and looking at the way both sides approached regulatory cooperation, regulatory coherence, which was supposed to be the big gain from that, and which continues to be relevant given everything that's happened since about China and China containment. And the interesting thing that I was writing about, to me anyway, was the fact that the US and the EU came with very different approaches to regulation. Where the US approach was all about providing companies with an opportunity to comment. It was more a private sector led approach, whereas the EU was coming up with more a regulator led approach, which envisaged a lot of regulatory dialogues. Now, the overall TTIP process ran out of time, so there was never it was never finalized. But in fact, that could have worked. But what is interesting is both the US then and the EU trying to project their approach to the rules globally, and that it probably, it came relatively close to succeeding. But it took some time to get there. From 2013, it was really only in 2016 that both succeeded, and the talks ended over other issues. But it might be something that both sides in the future look to take out of the cupboard and see if they can come up with common ground again, because although they came with different positions, they were actually capable of being reconciled.
That's fantastic. Thank you so much, David, for that. That was great. And can I now turn to Paul Cardinal and to Ramses Vessel? Paul, would you like to go first? I know you're both there.
Sure. Hi, everyone, and thanks again for the invitation, Elaine. So our chapter has been already highlighted by Advocate General Hogan, and thank you very much for the kind words. I did do a quick check on our chapter just to make sure we hadn't said anything about the opinion in Organisation Juive Européenne that might be controversial, but I'm glad to say not. So as we already heard, we came to look at this chapter not so much necessarily with convergence, but also on questions of divergence. And we looked at these cases which had sparked our interest about how the Court of Justice, I mean the EU generally and the different institutions, but particularly the court has got to grips with these very basic questions in international law of territory, which haven't really been settled, and the position that the court has been put in through cases on settlements in Israel, in Organisation Juive Européenne, and also the earlier case of Brita, certain the other cases of from Polisario in Morocco and Western Sahara and so on as well. And we noted the different approaches that the court has taken over time to addressing these issues. So what we were questioning there was, well, in the context of how the EU, or how the Court of Justice in these very early days set out the new legal order, what has that meant? Well, it's meant that through sometimes seemingly mundane cases involving trade or labeling and things, or have ended up in relatively small courts. In the Brita case, it was the Hamburg Finance Court, actually become questions about what does the European Union regard as the territory of another country. So which are highly politicized questions and also highly difficult. I don't think we envy the court necessarily having, or the Advocate General having to make these kind of decisions. What we look at then in our sort of conclusion part of our chapter is to really say that looking through this prism of territory, one of these things that, as I said, we assume is kind of settled in international law because of its core importance as a concept, helps us to actually understand both the internal and external dimensions of the way in which the EU approaches the specificity of its own legal system, as well as the use of international law and international legal sources as well. So it's still very much an open question, but given the frequency by which these questions on territories and disputed territories and so on have arisen in front of the court, it's something that the court is going to have to face with time and time again. I don't know if Ramses wants to add anything to.
Well, that's a perfect summary, Paul. There's nothing to add for me, I think. But other than perhaps what we also found, and is that the court seems to be quite selective in picking up international law, right? There does not seem to be a sort of coherent line in that. It sort of pragmatically seems to use international law in a certain way, and sometimes leaves out other issues that we thought were also important. But let me then, Elaine, if you allow me to use some other 20 seconds or so to thank Advocate General Hogan for his recent opinion in the Benkerifa Kagaran case, the CFSP case. And I just literally finished the case note on that one, which is on the CFSP's jurisdiction, and actually the non-contractual liability of the European Union in a CFSP situation. I was very happy with that opinion also, because it gave the court the push in the right direction. And I was particularly struck by the fact that the Advocate General simply used only one or two lines very convincingly to say that, of course, the court has jurisdiction in CFSP. How could it be otherwise? Whether so many other people, especially, of course, in the council, are still stuck within this old-fashioned pillar structure. Sorry about this, Elaine, but thanks very much.
No, fantastic. Thank you very much, Ramses, for that. That was great. Fantastic. Thanks very much, Paul, also for that. Wonderful. So we move on to Juan Sanchez-Vara and Laura Maslin about the Global Compact on Migration. Juan, hi, Juan, are you there?
Congratulations, Elaine, for bringing this project to a success. The aim of the chapter that I prepared with Laura Pasquale is to analyze the convergence and divergence between the Global Compact and EU migration policies, and also the implications arising from the internal division between the member states as regards the implementation process. We analyze the role played by the EU in the negotiation process, the adoption of the Global Compact, and we also analyze the breach of the unity in the international representation of the EU in the last months of the negotiation process. And in the last section of the chapter, we analyze the implications of the divergence among member states as regards the implementation of the Global Compact. Since 9 states didn't attend the Marrakesh conference and didn't approve the Global Compact, it's not clear. It's not what the EU is in the implementation process. The level of support to the Global Compact still differs inside the EU. The division between the EU member states raised the question of whether the EU and in particular the Commission and the working groups of the Council should play an active role for coordinating the implementation of the Global Compact. It has been argued that it would be more useful to use informal settings instead of using formal working groups at the Council in order to facilitate the implementation in the EU. The controversies surrounding the adoption of the Global Compact in the last months of 2018 and the lack of consensus among the member states have probably led EU member states not to discuss it at EU level, avoiding reopening the Pandora box in the last months. The risk in our chapter, we argue that the risk is the lack of coherence in the implementation among EU member states could have a negative impact on the EU external action. A more active engagement by the EU in the implementation process would contribute to assert the role of the EU in the international level. And finally, we argued in the chapter that probably that the new pact on migration and asylum to be presented in this year by the Commission offered a unique opportunity for finding common ground on migration and in particular on the implementation of the Global Compact. However, the truth is that there's no reference to the Global Compact in the new pact on migration and asylum proposed by the Commission last September. So this issue, it is still open. Thanks, Elaine.
Thank you so much, Juan. I don't think Lara is there, is she? So I'm going to move
on to she had some problems and some connection problems, and was supposed to do everything.
No problem. We'll move on swiftly then to Magda. Are you there? Hi, Magda. Magda.
Hi. Do you hear me?
Yes. Hi, Magda.
Oh, good. Okay. Hi. So my chapter. So I am a lecturer at the University of Zurich. And my chapter looked at the principle of solidarity in EU and international law in the specific situation of asylum seekers, migrants. And basically, I tried to see whether the recent developments or the recent crisis, migration crisis, has had an impact on the development of this very important principle. I thought that there was a lack of scholarship in terms of, a more recent lack of scholarship in terms of solidarity, because it's a very important principle, not only in the area of the refugee migration crisis, but also generally. But I had to confine my work to this most recent problem. Two remarks. I have to say two important considerations have to take in mind that the EU. I basically compared two legal orders, the EU and the UN legal order, in terms of the development of the principle of solidarity in the area of asylum and refugees. And two remarks had to be made is that, of course, two are very different. There are very different legal systems with very different aims. And the second was also that the subject matter which I was looking at is extremely complex, and that had an influence on how convergence had to be approached. That basically this made convergence much more difficult. It gave rise either to soft law at the UN level or more binding standards at the EU level, but with much less consensus. And so what interested me is that in the past, the EU has had a leading role in developing certain standards in the area of asylum law. This was, for instance, the case of subsidiary protection, and it has made an important contribution to international in this field. And I was just wondering how the impact of the very specific measures that the EU has taken as part of the mass reflux of migrants, what impact that had for the meaning or definition of solidarity in the area of asylum law. And although there was some convergence I found between the EU level and the UN instruments. By that I mean the 2 global compacts and the recent Declaration on International Solidarity. Of course, the UN was taking the lead in terms of developing a more concrete solidarity principle in this area, one that is, it claims should be enforceable. Of course, because it's also the difficulty in that is that because its declaration of international solidarity is not binding. The EU has also made some progress and has defined very specific standards and has developed the principle of solidarity in terms of defining physical boundaries, defining it precisely and setting numbers, or in terms of, it's what you call a physical solidarity. So it's in terms of how many people should be resettled, how much compensation should be paid. But it was very problematic in terms of human rights.
Could I just try to intervene there, just because we're running very short?
Yes, of course. I'm sorry. I'm finished. I am finished.
Thank you very much, Magda. That's fantastic. Thank you so much. We're very short of time, so just to be very brief. Thank you, Magda. Cornelia, could I move to you? Cornelia Papidi Kaliguru. Are you there, Cornelia? Hi, Cornelia.
Yes. Hello. Nice to see you again.
Please, yeah.
Okay, so my chapter focuses on the regulatory cooperation chapters in the new generation free trade agreement. So for more specifically in the CETA and EU-Japan, when our program, the EUT program started, actually these were the agreements that were very topical and relevant. So that's why my PhD thesis included them. So in my contribution, I try to understand, well, firstly to map and understand the use of law in the regulatory cooperation chapters. I begin from the hypothesis that there is a change through their inclusion within free trade agreements, especially when we think that in the past they were either addressed in the WTO arena through the TBT and SPS chapters and more specialized commitments, or in the transatlantic area through mainly soft law and political declarations. So what I try to do is depict the change, and I try to do that by using the methodological tool of legalization, which is actually a tool developed by international relations literature, and has 3 dimensions: legalization, obligation, precision, and delegation. And through the use of these tools, I depict the change that has happened with regard to the past. So for example, the obligation show us whether it's soft law or hard law, or if there is a continuum between these two areas. So I argue that for example, both chapters are included in legally binding treaties, so we're talking about hard law commitments. Precision is a tool about whether the commitments enshrined within the chapters are of precise nature or not precise nature. I argue that this depends on the chapters instead, because we see a much more precise outline of the commitments in CETA, but this does not really happen with EU-Japan. And last but not least, I analyze with the element of delegation whether it's a dynamic element within this chapter. So whether they are subject to international adjudication or they entail secondary rulemaking. And this is actually the only drawback with regard to their level of legalization. But to conclude, with regard to the past, there has been much legalization in the area of regulatory cooperation in the horizontal area, and that's my contribution. Thank you.
Thank you very much, Cornelia. Thank you so much for your brevity as well, but also for a fantastic piece. Akriti, Farja, Akriti, are you there? Hi, Akriti, and Jeff Kenner. Hi, Akriti.
Thank you, Elaine. In our chapter, Professor Kenner and I take the proposed EU-Mexico Free Trade Agreement as an example. And the chapter analyzes the potential for vertical and horizontal convergence on labor standards through trade. So by vertical convergence, we refer to the EU's pursuit of international labor standards under the ILO framework, whereas horizontal convergence refers to the provisions within the FTA that have an indirect bearing on labor standards. And therefore, they are relevant for advancing labor standards in trading countries. We are mindful of the influencing factors in our analysis, which are namely two. One is the external factor, which is dependent on the EU-Mexico trade. And the internal factor concerns rule of law within Mexico in connection with corruption and the enhanced role of the civil society in tackling it. So there is a competitive interdependence between the EU and the US as they compete in third markets. And Mexico is a part of asymmetrical regionalism to the advantage of the American economy. The coverage of labor standards in trade by the US is primarily for establishing political legitimacy. That is what the NAFTA negotiations taught us. The US does not predominantly advance the labor standards human rights approach in its trade agreements. And even the new US-Mexico-Canada agreement is more about political and economic rationale than the social policy-related aspects. Nevertheless, we find that the US approach may be more ambitious in respect of some labor rights, even if there is no labor rights, human rights interlinkages on part of the US. And some examples are when the US requires Mexico to incorporate the freedom of association in its domestic law and allow union activity and conditionality in trade negotiations. Moving very quickly.
Yeah, could I ask you just to yeah, thank you. Sorry, I'm so sorry.
So moving very quickly to civil society participation, the anti-corruption chapter refers to sustainable development goals, but does not make horizontal linkages with the trade and labor chapter. So there might be weaker horizontal convergence, which misses the labor standard anti-corruption interlinkage. Thank you.
Thanks, Akriti, for that. And apologies to rush you, just to be so brief. Jeff, hi, Jeff. Hi, Jeff, are you there? No. Jeff?
Akriti has spoken for both of us, Elaine, so I won't take up anymore.
Are you sure?
Yeah.
Thank you, Jeff, and thank you for a fantastic piece. Francesco, hi, Francesco.
Hello, everybody. Very nice to be here and to see you all in this format. Yeah, so my chapter is about regulatory convergence in the area of financial services, and I investigate whether equivalence, so this mechanism according to which the European Commission can grant market access to third countries if the regulation is equivalent to the EU, is a mechanism to only foster integration, or it's indeed used by the European Commission to also increase regulatory autonomy and the voice of the EU regulation at the international level. So I'm afraid I won't be giving any more spoilers because the time is very short. I advise you to read the chapter as well as the entire book, which is fantastic. Okay, thank you.
Thank you, Francesco. Thank you very much for your brevity and for a fantastic chapter in your summary. And last but not least at all, can I turn over to Isabella Mantini? Isabella, hi.
Yes, thank you, Elaine. Hi, yeah, it's very nice to see you all virtually. I hope that we'll have the chance to see each other in person at some time. So what I do in my chapter, I try to sort of, I make a methodological reflection or exercise to probe the usefulness of convergence as a methodological device for the study of the EU's external action, in particular for the EU as a global actor in trade and fundamental rights, which is the main and what I would say that one of the main challenges is to separate convergence as an approach and method from the phenomenon of convergence. Still, we can say that convergence appears to provide good lenses to select the relevant analytical elements, but much less so if we are to understand the normative direction of a phenomenon of convergence, in this case, when it comes to EU trade and fundamental rights. And I believe that resonates with some of the discussions also in the other chapters and the question of where and how convergence should occur when the EU acts in a global legal order, also as a global standard setter.
That's
Thank you very much, Isabel, and thanks. Isabel will defend her PhD just in a few days on this topic. But without further ado, it's just for precisely a time. Can I ask you just to raise a toast, if you have any kind of a beverage or whatever, to thank you very much for doing this project and for coming together. Just lovely to see you all, and thank you very much again to Abertana Hogan and to Anu for being here and for their many plans. So Sláinte, Prost, thank you very much to you all. Cheers, and to the end of 2020. Bye bye.
Cheers, everyone.
Cheers. Bye bye, everyone. Thank you very much. Thank you for coming. Very nice.
Bye.
Bye.
Thank you. Bye bye.
Thank you. Bye.
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 Bye bye. Bye.
Bye bye.
Bye bye, everyone. Bye bye, Juan. Bye. Bye.